and welcome to our audience. And what we plan on doing for the next 2 hours is going through a number of different areas that I trust you will find interesting. I certainly hope you will find interesting, but there are also areas that we are directed by statute to cover with all the regents and trustees. Let me briefly touch upon those areas. The content of our program here today will deal with enabling legislation that creates institutions of higher ed, the role of the governing board at institutions of higher ed, be it community colleges, four-year institutions, and our systems. The relationship between the governing board and an institution's administration, faculty, staff, including limitations on the authority of any governing board. We're going to deal with, to a limited degree, the mission statements of institutions of higher ed. And in terms of the disciplinary and investigatory powers of the governing board, we're going to touch on that as well. We're going to go into open government, pertaining in particular to the Open Meetings Act and how that can come up and bite you if you're not real careful. And a bite out of the Open Meetings Act could indeed carry criminal penalties. So it is a very important act to be conversant with. We'll deal with the Public Information Act. It's not quite as much of a concern of a board members as it is of a general counsel representing that board. We're going to deal at some length with the requirements of conflict of interest laws and other laws relating to governmental officials. And we're finally going to deal with applicable ethics policies adopted by institutions of higher ed, as well as the Texas Ethics Commission. And woven throughout, of course, will be a concern about protecting personally identifiable information of students because it is legally protected under the Family Educational Rights and Privacy Act, which oftentimes is referred to as FERPA. And so as we go through it, obviously, if you've got a burning question or a burning issue you want to address, please feel free to raise your hand. We'll call on you. If you'd rather wait until the end, we hope to leave a sufficient amount of time to answer at least a few questions at the end of the program. So with no further ado, I'm going to introduce our first speaker. He is Fernando Gomez. Fernando is the longtime Vice Chancellor and General Counsel of the Texas State University System. He was born in Gallup, New Mexico, earned his undergraduate degree at the University of New Mexico, and obtained at the University of Michigan, his beloved Wolverine School, his JD, enabling him to practice law, as well as his PhD in American culture. He went on to teach and attain tenure at Michigan State University before moving on to the California State University System as its general counsel, and then finally coming home to Texas as the general counsel of the Texas State University System. And so please join me in welcoming my friend Fernando Gomez, who will lead off the presentations.
Thank you, Bill. It's always a pleasure to work with a colleague of such a stature and really a fine gentleman, and a privilege to be in this panel. A kid from Gallup, I'm not sure I really could have ever imagined myself in this situation. I also want to thank the Texas Higher Education Coordinating Board and Vice Chair Stedman for the invitation. It's truly a privilege to be here. What we're really going to be talking about today is ethics, and not just ethics, but the rules of the state under which you are governed, under which you perform your duties and obligations as regents. Now, why is ethics important? Two fundamental reasons. One is, I believe, a legislative reason, and the second is really a fundamental reason having to do with human relationships. The legislative reason is that the legislature and the state of Texas is going to demand transparency. Transparency of whatever actions you perform, whatever, as a board and individually, your actions as a regent, those are going to be looked at, and the public has a right to see those and has a right to see, and Mr. Caputo will talk in handling of the Public Information Act precisely how that works. The second reason that we have ethical principles that we must abide by is because as a matter of human relationships with the institutions that you're governing, you have power. You have authority. You have, as a state officer who's appointed by the governor with the advice and consent of the Senate, who can be removed not by the governor, not by any authority, but through articles of impeachment. You have power. You will find that if you say something, either as even as an individual regent, something as simple as we'd take state planes from to visit the various campuses within the Texas State University system. I recall an instance in which somebody said, one of the regents says, gee, you don't bring along in your ice chest any Diet Dr. Pepper. Well, guess what? The very next trip there was Diet Dr. Pepper. Now it may seem like a small thing, but when you ask for something, either as an individual, you may ask for an accommodation, or you may ask somebody to look into something for you. It's going to be done. It's going to be done for you. And so you need to be very careful what you ask for. I've given you two handouts. The first deals with duty and general authority and duties of board members. And that has 16 points. Let me tell you what the 4 categories that subsume the 16 points: general authority and duties, conduct at board meetings, conflicts of interest, which gets very directly into the ethics code, and finally, relationships with the chancellor's staff and presidents. The first duty, and this is very much in the ethics code, is the duty of loyalty. Now, we had a president years ago that was asked to leave, we're talking in the late 80s, was asked to leave his position because the board wanted to make a change. And the board at that time was transitioning from a Democratic board to a Republican board, so we had appointees of both parties. And there was some crossover in this vote. It was a 5-4 vote. And during the course of those events, such a long time ago, unfortunately not in a galaxy far, far away, but what happened in those, in that situation is I had the 4 members of the board who were on the losing end of this discussion about retention of the president saying, well, how do we sue, and calling me aside privately and saying, well, how do we sue to get this undone? And I, of course, had to explain to them that I could not assist them in that because the will of the majority had spoken, and that there was no recourse to the people on the losing side, other than, I suppose, convincing a colleague to reconsider his or her vote. But what followed from that, and I can talk about it now 25 years later, 26 years later, whatever it is because there was a campaign then and they did not accept the decision of the board. And there was a very bitter campaign and an aftermath that was left. Why is that? Because their primary loyalty and I don't fault them because they were very close to this man, but their primary loyalty was to the individual, not to the institution. The loyalty that you owe as regents, you owe to the institution. You're not put on the board by the governor and confirmed by the Senate to advance the personal interests, obviously. You're not put on the board to advance the interests of higher education in the state of Texas. I've had a former board chairman that felt that was his primary mission in life, was to advance the interests of higher education. That's not his function. That's not any board member's function. That duty or responsibility is statutorily given to the Texas Higher Education Coordinating Board and the Commissioner of Higher Education. But nevertheless, you should be asking as you begin your service, how many of you are new to your boards? A fairly decent number. You should be asking certain basic questions. What do I have to offer? Well, what do you have to offer? You may have knowledge, experience, you may have relationships, sometimes political relationships. You may have a certain vision that you bring with you to the job. But you and you need to pick and choose within the organization those areas in which you want to serve. We've had general contractors that have served on our board that have been very interested in planning and construction. Our current board chair is a doctor and a dentist, and has been an academician for many years, and has also practiced medicine. Now, he's very interested in health issues. That's an area where he feels he needs to contribute. There are many ways that you can contribute, and I urge you and encourage you to talk to your chancellor, talk to your president, and try to find your place. The second duty under general authority and duties is not just the duty of loyalty again, but the duty of unity. Now, Mr. Caputo is going to talk to you later in this session about how board members, or how boards of regents and boards of trustees operate. And you basically are a body corporate. When you are acting as a trustee of the institution or of the system, in my case, the Texas State University system, we have a campus in, let's say, Lamar University or Lamar University Institute of Technology. When the board is acting on a matter pertaining to the Lamar University Institute of Technology, or the Lamar Institute of Technology, excuse me, it is legally the institution. The board is legally Texas State. The Texas University of Texas System Board legally is the University of Texas at Austin, and the University of Texas at Arlington, and the Health Science Center at Galveston. You are the legal entity through which these institutions function. The most important attitude that you can bring to the board, aside from the concept of service, is the concept of independence. I've left you a statute in your materials, and it's Chapter 51 of the Texas Education Code. And what that essentially says is that the primary function of a board of trustees or of a board of regents is to preserve the institutional independence of the colleges and universities within their purview, within their system. Is there a question? Thought I heard something. But also the right to govern your institution through representatives and through employees, presidents, and others of your own choosing. Now, I want to say something here that I don't want to be misunderstood, but I think it's a very important concept. Now, you are appointed by the governor, and there have been situations in the early 80s. There was a dispute, or the late 80s, there was a dispute on our board. The two people wanted to be chair. One was very close to a governor of Texas. I'm not going to say whether the governor was Republican or Democrat, he or she was Republican or Democrat, but the governor called the incumbent chairman of the board and said, I want you to choose this person. And the chairman said, well, Governor, we're going to talk about this, and we're going to select the person that we believe is best suited to the position. The governor said, you're not listening to me. Lee, you're not listening to me. I want so-and-so to be chairman of the board. And Now, he picked on the wrong fellow because this is a Sam Houston graduate who had been on the board, eventually served on the board 19 years. And he said, Governor, if you want to make this decision, then you will have my resignation this afternoon, and I will make sure that the public knows that you did not wish to select in that case. It happened to be an Hispanic accountant from San Antonio, Texas, why you didn't want him to be the chairman of this board. And the governor, to his credit, backed off. That's the kind of independence you have to. I'm not saying you be defiant with the governor that appointed you. I'm not saying that at all. I'm not saying you don't listen to the governor that appointed you or to senators that may have confirmed you. What I'm saying to you is that your primary responsibility is to look after these institutions as a body corporate. Not as an individual, not to make individual decisions, but as a body corporate, to look after these institutions and collectively make the judgments that you all feel are in the best interests of the institution. That's your primary role. The duties of the chair: to provide leadership, to act under a general grant of authority, but not to exercise authority that has not been granted. Committee or administrative authority, many of the, talked about this before in the sense of talking about where you want to contribute. You will have committees that you may serve on, and those also are intended to advance the interests and to help the board do its job. Conduct at board meetings: you have a right to speak, and in speaking and voting, you follow your rules. Oftentimes, it's not infrequent that somebody doesn't like a rule that's on the books. Well, we don't want to do that. We don't want to do ABC. Well, I'm sorry, but that's, your rule says that you can't do ABC. Well, we'll just pass a resolution that undoes it. No, that's not the correct process. The correct process is you notice up an item for an amendment to the rules and regulations or the policies of your institution, and then you notice them up for public hearing and public vote, and you act on them, and then at that point in time you can go ahead and proceed as you believe appropriate. Look, rules are put there for guidance, to provide direction, to provide some measure of order. That's what the law is about. That's the majesty of the law. That's the majesty of our legal system. And that we have rules, they're set in place for the general good, and the legislative body, in this case, the Board of Trustees or the Board of Regents, as the case may be, has authority to pass and promulgate rules. Under conduct at board meetings, you have a duty to listen and to respect board decisions. As with the folks that didn't like the changeover in the presidency of one of the institutions, you may not like those. A lot of times you're probably not going to like those decisions. But you have a right, to speak your piece. And in fact, there is a statute, a government code, that says, that's quoted here for you or cited here for you, that says that if you want to state a minority opinion, you may certainly do so. And it is your right to have that minority opinion entered into the minutes, and that kind of dissent is entirely proper and appropriate. You have a duty of confidentiality. This is also in the ethics code. And what this means is what you talk about in executive session as regents, what you discuss with your counsel, the kinds of policy advice, opinion, advice, recommendation that your chancellor or president may give you. All of these are privileges that the law respects. And you are to hold those privileges. You are not to disclose them to any third party. You are to hold those. In fact, even as Mr. Caputo will tell you, that there is a judicial process for the disclosure of what goes on in executive session. But what happens in that behind closed doors, you can't vote, you can deliberate, you can't vote, but what happens there should be sacrosanct. And if you do disclose what happens there, it could have some dire consequences, the loss of an attorney-client privilege, and it may impact you, in fact, adversely. Conflicts of interest on page 2 of the document. I'm not going to spend too much time on that. I think my colleague, General Counsel Cornell, is going to talk in this area. Basic rules. Well, let's talk about ethics for a moment. Ethics, essentially, and we have a code of ethics. Ethics is a principle that has 4 characteristics. One, it is ethical principles are of great antiquity. There's reference of ethical codes in the Old Testament, in the Talmud, in the New Testament, in the Quran. The Golden Rule itself, to do unto others as you would have others do unto you, is from Confucius of all places. They're of great antiquity, they're universal to the human condition, and I really can't tell you anything about ethics that you shouldn't know, you shouldn't feel inside, that you shouldn't have learned at your parents' knee, at your grandparents' knee. But also, ethics are largely unenforceable. Even though we have an ethics code in the state of Texas, it's very difficult to enforce, and there's just aren't the mechanisms in place to enforce it in a meaningful way in all situations. So it's really, in a real sense, sort of like an honor code. And then finally, I think ethical decisions that we make are private decisions that often have wide-ranging consequences. Let me tell you what I mean. I didn't give you a story at the inception of the conversation or of the monologue, or whatever you want to call it, as I normally do. Chernobyl, the meltdown at Chernobyl. And this is, and my ethics compels me to attribute this story to the person that had the insight. There was a man named Rushmore Kidder, who is now deceased, who ran the Center for Global Ethics in Maine. And he talked about how this accident happened. The engineers, very, very proud of this multi-billion-dollar machine, are shutting down the reactor. They're shutting it down, and they're letting it kind of heat up until they kick it back on. And they do this one time, a second time, a third time, and every time, and they're very proud of this machine, and because it's always going to go back on. This has backup systems to backup systems to backup systems, and the 4th time finally, when they kicked it off, they couldn't get it back on. Now, this was not an illegal decision, but it was a very bad ethical decision. This is something it was a private decision that had some benefit, and the benefit being amusement in this case, to the people who were performing the act, but it had little, in fact, very negative public consequences. And we see these decisions on the news all the time, There's a football coach, don't want to denigrate the football coach, that got his dream job at the University of Notre Dame until they found out, the university found out that he actually didn't have the master's degree that he had represented on his resume. As a U.S. Olympic Committee director of the U.S. Olympic Committee, who was Dr. Jane Doe. And it turned out Dr. Doe was not Dr. Doe at all. She didn't have a degree. She didn't have any degree. And she was asked to leave. There was a television anchor or a television reporter in Los Angeles a few years ago that had been asked to do a story on the marital difficulties of the mayor of Los Angeles. Now, she failed to disclose to her employers that she was in fact dating the mayor of Los Angeles. Okay, not an illegal act, but this is something that you should disclose. the professor at Mount Holyoke University who regaled students with these marvelous stories about his service in Vietnam. As the most popular professor on campus, he did a great job with his classes. Problem is, he never served in Vietnam, he never served in the Army. Now you might ask, well, what harm does this do? Well, it does harm. It may not be monetary harm, like the fellow that sat in Hong Kong at his computer and somehow managed to shut half the banking system of the world. Wells Fargo, let's talk about Wells Fargo. And the encouragement of their employees to set up accounts that people, in fact, did not ask to be opened. You know, the examples are the university professor, the university president years ago. Now, this is in a galaxy far, far away and a time long, long ago, who used his state credit card to make charges at a gentleman's club. He ended up in Florida. I'm not denigrating Florida, those of you from Florida, but these were decisions that people, for some reason, think are okay, and they're really not okay. You know, you know what's right and wrong. You know if it doesn't feel right, or if it's something that I've got some rules that I'm not going to go over in any great detail, but you know, if it doesn't feel right, if you'd feel embarrassed or uncomfortable if what you did became public, then it's probably wrong, probably something you shouldn't do. But there's a difference between ethics and law, and we're going to talk about some of the, in a couple of minutes. I know that General Counsel Cornell is going to talk about some examples of some of these ethical lapses. Let's talk a little about relationships with the chancellors and oh, by the way, on conflicts of interest, we're going to talk about gifts and bribes, I know. We're going to talk about business or professional activities, independence of judgment I've talked about, and finally investments. Bottom line is you don't get to self-deal. We had one final ethical lapse. We had a professor on one of the campuses that was receiving federal and state grants. And when he signed the contract on behalf of the university, the authority was granted for him to sign a contract with an outside provider of the expertise that the university was looking for to carry out the terms of this grant. He signed a contract with his own company. He signed on behalf of the university, Jane Doe, and on behalf of his own company, Jane Doe, CEO. Now, I don't think anybody should have to tell him, that's like playing with a reactor, maybe not as bad, but you should know you don't deal with yourself. And the law is very clear. You don't engage in business or professional activities that are going to cause you to do one of two things. Either disclose confidential information gained by reason of your position, or two, to divide your loyalties. We had a dean that was put in charge of a new online program a few years ago. Now, the party that we contracted with, and she was not part of the negotiations, paid her $25,000 as a consultant to manage that contract. Well, what's wrong with that? Well, she was already in charge of managing the contract on behalf of the university. Now, supposing she's in President's cabinet talking about maybe searching for another vendor, or searching to expand the program overseas and looking for another vendor. Her duties are going to be, her emotions are going to be divided. And so she's not going to do what she's supposed to be doing as a state employee, not to mention the fact that should have been disclosed. The executive's role, respect the executive's role. You know, you've hired a president. Many of you have been on my board and on other boards. I know you've accomplished marvelous, wonderful things in business, in the professions, in different areas of human endeavor. And if you've spent the last 40 years building up a major company, and you become wealthy or you become affluent. It doesn't matter if you built up a law practice or a medical practice, and you're very, very good at that. And I don't think any president who doesn't share that experience, or any chancellor who doesn't share that experience, ought to tell you how to run your business or how to do the details of your profession. But yet, what I'm saying essentially, in as polite a way as I know how, you have people who are working with your universities and your institutions and your colleges that have spent the same 30, 40 years doing what they do, learning how to be academicians, learning how universities function. People that are at this table have spent those same 30 or 40 years advising others on how to follow the law and how to obey the law and how not to disobey the law. And so you have to respect. Now, if you don't respect your executive, find somebody else that you can respect. But these people are entitled to your support. In fact, the law says that one of the reasons that you're there is to support and make sure that your executive is successful. One last thing, I'll say that there are examples of policy, things that are very clearly within the purview of governing boards. The opening of a satellite campus, for one. 2, hiring a chancellor or president, evaluating the person's performance. 3, whether or not to buy or sell land on an interstate or any place for that matter. That's a board decision after a certain amount, if it's been delegated. To issue bonds, to sell bonds to finance your infrastructure. What's not policy? Termination of a vice president or dean. Somebody's mean to you while you're on campus. Well, sorry about that. We'll talk about courtesy to the individual, but we don't fire them for that. Student discipline. Sometimes people get away or appear to get away with some bad things. I promise you that's not generally true that people get away, but sometimes it happens. But yet that is a function that is delegated within the internal workings of the organization. Strategies for retention of students, for recruitment of students, and decisions as to what curriculum to use, what textbooks to use. I know in K through 12, the TEA is arguing about a textbook right now involving a certain content. And now that's appropriate for TEA. It's not appropriate because in a university or college setting, because those decisions are academic and made by the faculty and the administration. You have much to offer, I am convinced. It's been my privilege to have worked with my board. I have not found them to be anything other than very decent people who 99% of the time look beyond politics and look beyond ideology. The only the instances of ideological thinking that have come in are few and far between. I was telling the panel at lunch about a chairman or a regent that got up to do an invocation and asked God to strike down these evil terrorists, and he used some very graphic language about it. And of course, he wasn't asked to do the invocation again, but essentially, I guess what I'm telling you is that it is a privilege to work with these institutions. You were selected, I'm sure, for what you bring to the table in terms of qualities of character, qualities of mind, achievement. Please understand the nature of your role and the independence and the awesome power that it gives you, and I hope that you do, and I'm confident that you will exercise that authority just as a body corporate, absolutely to the benefit of these institutions and colleges and universities of the state of Texas. Thank you.
Thank you, Fernando. Nice job, as always. Our next speaker is Kabi Caputo. Kabi is a school lawyer and has practiced law in that area for years and years. He represents both independent school districts, community colleges, and from time to time delves into the four-year realm. He specializes in Title VII and Title IX lawsuits and other civil rights litigation. He holds a Bachelor's of Arts degree from the University of Texas at Austin and a JD from the University of Texas at Austin School of Law. He was admitted to the Texas bar some 27 years ago, and I probably should have noted at the outset that collectively, the four of us probably have about 150 or close to it years of practice. So,
That's true.
just to say that we're old. At any rate, with no further ado, let me introduce you to an excellent attorney and my friend, Kabi Caputo.
Thank you, Bill. I have the official nameplate up. So I'm going to speak to you all today about what Fernando was alluding to, which is that as a body corporate, you have to take action as a group. And the way you do that, whether you're a regent or a trustee, is through, hold on a minute, technical issues, through a public meeting. And so the first part I'm going to talk about today in terms of open government is the open meetings law. And then I'll talk some about the open records law, which doesn't, as was noted, doesn't affect you as much, but there are certain things you should be aware of. So the first thing we need to talk about is what is a meeting. So you have to act through a meeting. So what's a meeting? The Texas Government Code at Chapter 551 is the open meetings law, and its definition of a meeting is a deliberation between a quorum of a governmental body or between a quorum of a governmental body and another person. So keep that in mind. We're not just talking about when you're talking with each other, it's when a majority or a quorum of you are talking to someone else. That's a very important distinction. During which public business or public policy over which the governmental body has supervision or control is discussed. Or, and this is a big thing, or at any meeting at which action is taken. So just to talk about that just briefly, there was a time, a long time ago, when people thought, well, we can talk about anything as long as we don't act. The important thing is that we don't act without the public knowing we're going to act. And that was changed a long time back in the 90s to make it very clear that even discussions amongst a quorum of the board constitute a meeting if you're talking about public business over which you have control. So the two things we need to talk about then is what is deliberation and what is a quorum. So a quorum in the statute is defined as a majority of the board, but there may be, and it says, unless you've got some other law that says otherwise. So in a lot of cities, they have a different definition of a quorum. You may have a governing statute that has a different definition. I think they all pretty much say a majority now. But if you have a question on that, you might want to check with your counsel or someone on your staff to make sure. But generally, if there's a majority of you present, there is a meeting. And then deliberation is defined as a verbal exchange during a meeting, so it's a bit circular, during a meeting between a quorum of a governmental body or between the quorum and another person. So those are the two really significant categories. For a long time, again, long way back in the day, it was assumed if we're just listening to somebody talk, we're not having a meeting. That the important thing is we're talking amongst ourselves. And as we said, that's been clarified, as well as we're not taking any action. So if there's a majority of you present and you're talking about public business or someone else is talking to you about public business, you're in a meeting. And the important thing at this point is that meeting needs to be properly posted. And to be properly posted, it's a technical thing that you all don't get too involved in, but generally, there needs to have been 72 hours notice of a public posting that lists the things that the board is going to talk about and potentially take action on. And it has to have enough specificity that a person who's generally interested would know what you're talking about. And so that becomes an issue that people consult lawyers on a lot, is how much detail do we have to put down? And there's been some litigation about that in the K-12 world, being what it is. There was a case about a athletic director that was fired by a school district, and they didn't put, we're going to consider terminating the athletic director on the agenda. They just said, we're going to talk about personnel. And the court determined in that case, this was an actual court case, not just an AG ruling, that some positions are so high that they sort of have a de facto public interest. And so you have to put at least the position. So again, in K-12, superintendents, athletic directors apparently, football coaches probably, you always have to put down, we're talking about this person. And in your world, you would need to do that if you're doing the evaluation of the president or chancellor. You can't just put personnel, you need to put down, consideration of contract or whatever of the person. Again, that's normally going to be done by staff, but you want to be careful about how that's done. Another type of meeting, or a thing that is not a meeting, is if you are together in a social setting. There's a specific provision in the Open Meetings Act that says if you're just together socially, having dinner at somebody else's event and there's a quorum of you present, you're not having a meeting unless public business is being spoken about. And so again, you need to be careful about that, if you all are having dinner at someone's house, for instance, which I know, trustees do that occasionally, they'll all get together and have dinner. If someone starts talking business, you need to stop it quickly, or you need to leave, ultimately. Another exception is if a quorum of you have gone to a meeting like this, a conference or a seminar, as long as you're not taking any action, and as long as the discussion by a third person, for instance me, to a quorum of you is about the topic of the conference. So it's incidental to the meeting that you're attending. But again, you can't take any action while you're here. So there's sort of a practical aspect to this that you might want to consider, just not being together in numbers of greater than a quorum, because people might see that. If you're all at a restaurant having dinner, someone might notice, oh, by the way, that's the entire board of trustees of the college. And people will begin to wonder, what were you talking about? And then the burden may fall to you to try to prove we did not discuss business at all. We talked about football, or we talked about politics, not our politics. So as a matter of self-preservation, you're just better off never being seen in groups of more than a quorum to avoid problems. And why are we concerned about this? Other than, as Fernando was talking about, you're doing the right thing, you're being transparent, the public has a right to know what you're doing because you're conducting public business, you're expending public funds. The public trust ultimately is tied up in what you're doing. If that's not good enough, there is a criminal penalty associated with this. If you are convicted of violating the open meetings law, you can serve up to 6 months in jail, and you can receive a fine of between $100 and $500. So sometimes people say, oh, has that ever happened? Well, about a year ago, a complaint was raised in Smith County about the county judge, that he and the commissioner's court had violated the open meetings law by giving a contract to a company called ATS to put in unmanned cameras to give tickets in school zones. And the county judge of Smith County was indicted in June of this year and is facing 3 charges of violating the open meetings law. And he was arraigned in August. He's out of office now. There's some other things going on with him as well. If anybody's here from Tyler, there's some other issues with him. But he is still facing these criminal charges. And his trial was supposed to be taking place, I think, around now, but they just granted a continuance because a key witness was missing. And I can't give you a lot of details about, what his thinking is on all this. But what happened was they had an agenda item at one meeting that said a presentation by ATS on public safety issues. And that never occurred. When that agenda item came up, the county judge said, yeah, we'll table that. That's not going to happen tonight. What happened was they went into closed session, the ATS representatives went into closed session with the commissioner's court and talked about, we can give you these cool unmanned cameras that will, allow you to ticket people who are speeding through your school zones. At the next agenda item, or the next meeting of the Commissioners Court, there was an agenda item that said, consider contract procurement matters. Didn't mention ATS, didn't mention the cameras, didn't mention anything, just a generic, we're going to talk about procurement matters. And they apparently discussed this contract, at least according to the indictment. And then at the next meeting, which was in August, that same language occurred, consider procurement matters. They went into closed session to do that. When they came out of closed session, the county judge said, I need a motion to award a contract to ATS to provide us with these unmanned cameras. That motion was made, seconded, they awarded the contract. And that's actually what triggered some citizen watchdog group didn't like the idea of the unmanned cameras, and they're the ones that brought this issue to the fore. Now, this isn't the district attorney or the county attorney in Smith County prosecuting him. They turned it over to the Attorney General. The Attorney General's office has a division that does investigations into violations of the open meetings law. And so this is a very real thing. It can happen to you. I have served on the city council in Cedar Park off and on for many years. And during one of the times I was not on, just to be clear, I was not on the council when this happened, our city was investigated for violating the open meetings law when a group of council members met at the city attorney's office and told the city manager he was fired. They didn't even bother to have a meeting about it. They just told him he was fired and to not come to the meeting tonight. In that case, one of the city council members who was not at that meeting called the Attorney General and complained. And the Attorney General contacted the district attorney's office in Williamson County, who said, we really don't want to get into this. And they sent down sort of their flying squad of investigators and investigated our city council and ultimately entered into a plea bargain deal with the city council members that were involved. So it is something that happens. It is something that is out there, and you need to be worried about because, I don't want to spend 6 months in jail just because we talked about something that we didn't properly notice. So that's a real thing. Now, some of you probably have a agenda category for citizens communications. You may call it, something else, but it's generally to allow citizens to come talk. And if what they're talking about is not something that's already on the agenda, you're usually told by your lawyer or you've got rules that say, we can't respond to that. And some people say, well, why is that? And that's because sometime in the 90s, the Attorney General's office determined that because whatever that citizen is speaking about was not posted, the rest of the public doesn't know you're going to talk about it, and therefore you can't have a deliberation with that person where you have a back and forth. Under a strict reading of the law, you probably shouldn't even allow them to speak. And that's what the Attorney General first said in, I can't remember if it was 98 or 99. But his first decision was you can't even have a citizens communication agenda item. Because remember that definition is if a quorum of you hears from another person. And he said, well, you're hearing from another person. You're all there, and they're probably speaking to you about something, that's within your jurisdiction as a body. And so initially he said, you just can't even have it. And there was a bit of an uproar. A lot of governmental entities challenged that. And he reconsidered the opinion, and he finally said, okay, you can hear from the public, but you cannot respond. And so that's why your lawyer will tell you if someone speaks in citizens communication, you can't respond to it. There are some ways to let them know you heard. Any member of the board can say, I would like an agenda item on a future topic about that. There's a specific provision in the government code and the open meetings law that specifically says, if something comes up in a meeting that's not posted, someone on the board can say, I want to talk about that at a future meeting, and that's allowable. You can also ask your staff, what is our current policy regarding this topic that they came up with, and the staff can give you a factual account of what the policy is. But that's the limit of what you're allowed to do in response to a citizen's communication of something that's not on your agenda. So just be aware of that. Most of you have probably experienced that at your meetings where someone says something and there's people up there just raring to tear into them or argue with them about it or yell at somebody else about it, and you just can't do that. So let's talk a little bit now about closed meetings, which is what got Smith County into trouble. So there's a number of exceptions, and most of you are aware of, you can go into closed session to talk about buying real estate, or to consult with your lawyer, or to discuss personnel matters, or if you, I don't think any of you are, but if you have some rule that says you can consider student disciplinary matters, that kind of thing, you could go into closed session, but you have to have that on the agenda, that we're going to go into closed session to talk about real estate matters or whatever. And as you see, you need to have some specificity to what it is you're going to talk about. What you talk about in there is considered confidential, and there has to be either a certified agenda kept, which is something signed by your presiding officer that says, we talked about these things in closed session. Or you have to have a tape recording of what happened in the closed session. And both of those documents, whether you tape record or you have a certified agenda, are considered completely confidential under Texas law and cannot be released except if someone sues you and says you violated the open meetings law. At that point, the court is allowed to look in camera at what's in the certified agenda or listen to the tape recording and see what's on it. The only people that can ever see the certified agenda or listen to the tape recording otherwise are the elected officials. And that happens from time to time. Someone will miss a meeting and they'll say, hey, can I come look at the agenda to see what we talked about? Other than that, those two documents are completely, and it's in fact a criminal offense to release those documents. So if you ever find yourself in possession of them, you do not give them to somebody. You turn it over immediately to whoever is your keeper of those documents. If you're going to take action, you cannot do it in closed session. There was a case involving the Austin School District and the Statesman newspaper, Cox Enterprises, sued them over them basically having a straw poll in the closed session about which of the different candidates for superintendent they were going to hire. That went all the way to the Texas Supreme Court, and the Texas Supreme Court said you can't have straw polls in there. So be careful. You know, sometimes in a closed session you'll be talking about, should we buy this property or that property, and somebody's trying to resolve that and say, so do you want us to go for this one or that one? Do not have everybody in the room go, well, I like that one. That might be considered a straw poll. You might get into trouble for that. So you just have to be cautious. If you're going to take action, you need to get out of the closed session, come back into open session, and then have a vote. And you know, as Smith County is finding out, ideally you have something on the agenda that says you're going to be taking action on something like that. So be cautious about those things. At times, again, you may have an attorney in the closed session with you that says, hey, we can't talk about that, or we need to cut this off because we're not on the agenda anymore. And again, we're not really trying to ruin your fun or stop you from having a full-throated conversation. We just don't want anybody to go to jail. So I will tell you, in Smith County, one of the county judge's public statements reported in various media was our assistant county attorney was there with us the whole time. And so if something illegal was going on, I kind of expected him to tell us otherwise. So that is not necessarily a defense. And so be aware of that. Just because the lawyer is sitting in there nodding along while you guys talk doesn't mean that what you're doing is free from potential criminal sanction. So again, I don't necessarily think the only reason you should do these things is to avoid jail, but for some people, you know, that's sort of the level they operate on. You know, ideally we do these things because we want to be compliant with not just the law, but good government practices. Now you're gonna make me put my reading glasses on, aren't you?
Oh.
Been handed a note by my associate here. Yeah, so the comment there was that if you're discussing things with your with your attorney in closed session, it's considered not a meeting for some reason, and you don't have to keep the certified agenda or have the tape recording going. That's a twist of the law. And then what you're supposed to be talking about is something that's on the agenda. You can't just say consult with attorney and go into the closed session and talk about anything that you have a question for your lawyer. What you go into closed session for, and the way this happens, and this is something pertinent to you, the way it should happen is that the presiding officer says, we're going to go into closed session to discuss agenda item, you know, whatever. And then they're supposed to read off the particular exception out of the law that you're going in there for. So if you're going to talk about purchase of real estate, we're going in under section 551.074, or is that personnel? That may be personnel. I think 7.2 is real estate. Or 071 to consult with our attorney about this agenda item. And so it needs to be tied to an agenda item. It's not just a get out of jail free card, go talk about whatever you want. And some people kind of chafe at that. So the posting that has to be done, these days, I think most of the four-year universities and any community college that's over 20,000 students has to post their agenda on their website. And they have to post the materials that have been provided to the board by the staff. So the public also has access to those materials. So be sure you're doing that if you're not. I think most everybody has kind of come around to that, because I think for the 4 years, that happened a long time ago. For the community colleges, that happened at least one session back, maybe two. So be careful about that. And then we also nowadays, any community college over 20,000 has to broadcast over the internet, which I'm not sure what that means, but you have to broadcast over the internet a recording, a video recording of your meetings. So I think most people had already gone to that anyway, but the legislature went ahead and put a boundary on it that if you have 20,000 students or more in any semester the preceding year, you're subject to the internet streaming rules. And I think that applies to the 4 years as well.
For regularly scheduled meetings.
Yeah, for regularly scheduled meetings, right. If you have committees, and a lot of people do, a committee meeting doesn't necessarily have to be posted and comply with the terms of the act, but there's a bunch of conditions associated with that. So if you have a quorum of your board on the committee, of course, that's a quorum and it's a meeting. But if you just have 1 or 2 members of the board or 3 members of the board on the committee, technically that's not going to be a meeting because there's not a quorum present. But then there are sort of these riders associated with that. If the committee can take action, if they've been authorized to take action, then that is a meeting and that needs to be posted, even though it's not a quorum. If the actions of the committee are routinely just rubber stamped by the whole body, you can be in a position where you should have posted that. Another one that comes up quite a bit is you have these committees and they have meetings, but the majority of the rest of the board shows up too. You know, we're all very interested in what's going on, or we don't trust those scoundrels, and why we put them on this committee in the first place. You know, for whatever reason, you have other trustees showing up or other regions showing up. If that's the case, if there's suddenly a majority of you in the room, that's a meeting, and if it wasn't posted, you need to stop it. So generally, as a lawyer, I give fairly conservative advice to people, so again, to avoid going to jail. Just post your committee meetings. It's just easier that way. You may have the public show up, but again, why would we object to having the public watch our committee, you know, our finance committee talk about our money, or, you know, facilities committee talk about our building program. We should be open and willing to have the public oversee us because, again, it's their money we're dealing with. And again, it really comes down to a matter of their trust in what we're doing. So if you have advisory committees, which a lot of people do, it's the same rules. If there's a majority of the board on there, then that advisory committee is a meeting. If there's 1 or 2 of you and a bunch of regular citizens, that may not necessarily be. But again, if there's a rubber stamp kind of situation or the rest of the body is showing up, you'll need to post those as well. Most of you know the legislature is trying to help us do video conferencing. I think the 4 years have had this for a lot longer than us in the community college world, but it was very complicated to do. You had to have everybody who was going to be attending by video conference had to be in a public place, and it didn't make any sense. So what they've done now is they've changed the rules to say, nowadays you just have to have 1 member in a public place. You have to have the presiding officer in a public place. Everyone else could attend by video, and everyone else, as long as they're visible to the public and the public can see them and hear them and they can see the public when the public speaks, you could theoretically have a meeting where just your presiding officer is present in the public room and everybody else is calling in from their house. I do a lot of work with Austin Community College, and we just had our first meeting where somebody attended by video conference, and it was a little exciting and a little confusing at first because, you know, when that member wanted to speak, somebody had to be looking at the monitor to see that she had her hand up, or there's a bit of a delay, you know, just because of the way the internet works. And during the Pledge of Allegiance, you know, that member was slightly off from everybody else, so there was a bit of a... So we're going to work on those sorts of operational level details, but just be aware, if you're going to be out of town, you can video in from your, you know, wherever you are. I know a lot of college presidents I've talked to have said, you know, we don't really want to get too deep into this because we will ultimately end up with you know, everybody else at home phoning in by video, and everybody, you know, will have a person in the room. And, you know, there's a whole lot to be said for having everybody together, at least the majority of you together, in terms of the dynamic of how it works. You are required under law to receive training on open government and open meetings. This is not the training, so if any of you were hoping that this portion of this speech was going to get you through your training, it's not it. There's a mandatory training. Most people do the Attorney General's version of it now. You can just watch it online. But you do need to do that within 90 days of taking office. So again, your staff are probably up to speed on that, and they're going to give you everything you need. But just be aware, if it's a couple months into your tenure and nobody has said, hey, have you watched the AG Open Meetings and Open Records training, you might want to raise it yourself. So let's shift to talk about open records just a little bit here. There was kind of a running gun battle for a long time between the Attorney General and different elected officials about whether those elected officials' computers, their emails at home, not their public ones, or their text messages or their internet postings, are those public records? And the Attorney General always said, as long as you're talking about public business, we don't care where it is, what medium it's on, who's storing it, it's officially a public record. And there were various lawsuits going about that, and last session, the legislature, maybe it was 2 sessions ago again, the legislature settled that and said, it doesn't matter what the medium is or how you're doing it or where you're storing it. It is, if it's about public business, it's a public record and is subject to the Public Information Act. So you may have already experienced it, but there's a lot of, the watchdog types that have been following these things, and they're doing open records requests now saying, I want to see all text messages between the president or chancellor and the trustees, or we've got to produce those now. So, some people used to think, oh, well, I won't, send an email because that will probably be traced, but I'll just fire off a text message. That can also be a public record now, and we do have a duty to not only produce those if they're asked for, but we have a duty to preserve them under the different statutes that govern preservation of public records. So the way that statute reads now, it says, public information includes email, internet postings, text messages, instant messages, or other electronic communications. So think about that. How many of you are elected officials and you have a Twitter account? If you're tweeting about public information, you better be sure that that's being stored somewhere. If you're posting things on people's Facebook pages about your organization or the public business in some way that relates to you, you need to be able to recall that when somebody does an open records request and says, I want to see all Facebook postings by Councilmember Caputo for the last 6 months to deal with city business. And I don't know how I would respond to that if it happened. But we do have a duty to produce those. Official business, which is the key there, is now defined as any matter over which a governmental body has any authority, administrative duties, or advisory duties. So again, very broad. The general rule is the state is trying to tell us we want the public to be able to see what you're doing when you're conducting public business. So, you can't hide it by doing it as a text, because everybody used to think text messages just disappear. And they do if you delete them off your phone, but you may be destroying public records at that point, which is its own criminal penalty associated with it. And then I'll close with there's a, sometimes people think, well, these are old and, hoary areas of law, and it doesn't really develop much anymore other than when the legislature meets. The Texas Supreme Court had an oral argument last month on an open records question involving the city of Dallas about whether or not the attorney-client privilege applies to a document that was not initially created by the lawyer, but was routed to the lawyer for purposes of getting some advice on it. And so there's quite an argument going on about, well, that's not really an attorney-client document because the lawyer didn't do it. The lawyer didn't tell somebody to do it. Somebody did it. It was a report on somebody else's activities, and then they sent it to the lawyer to say, give us some advice on this. What complicates that even more is that Dallas didn't bother to raise that exception when they went to the Attorney General initially. And the way these things work is you get a request, you have 10 days, 10 business days, to send a request to the Texas Attorney General saying, hey, we think these exceptions apply. And the Attorney General is pretty strong about, hey, if you don't raise the exception, we're not going to consider it. And if you don't raise it within those 10 days, you've waived that argument. And Dallas didn't do it. Dallas forgot to raise that one at that time. So it's been working its way through the court system. As I say, it was argued in front of the Texas Supreme Court last month, and we should get a ruling sometime in the next year. But that's sort of an extreme situation where something is not even bothered to be raised, and then they raise it later. Where the lawyer didn't produce, it's easy to say, hey, I sent my client an email giving them advice. That's easy to say, that's an attorney-client document. But a lot of the public watchdog groups are concerned that this is going to create an exception that is just, it consumes the rule, because everybody will just copy the lawyer in everything they do. And, people who are trying to hide things can then say, oh, well, that was an attorney-client communication. So doing that does not accomplish that end. So be aware of that, because I'll get that sometimes from clients. You know, they're having some internal conversation about things, and somebody along the line loops me into the conversation. And I will at times send an email that says, just so you all know, I am not acting in my role as an attorney on this, because no one's asked me a question. No one's put a topic to me asking for some sort of advice or recommendation. So, you know, this is not going to be, and they just need to be aware of that. So again, there's criminal penalties. No one wants to be the one that goes to jail for these kinds of things. But really, you need to keep the public trust. You need to let the public know what you're doing. We shouldn't be doing anything we need to hide from the public in any meaningful way. Once we decided what piece of land to buy, you know, there's no reason to keep that secret. Once we've made decisions about personnel matters, come out in public, do that, let the public know what's going on. And with that, I will turn it back over to Dr. Franz.
Thank you, Kabi. Appreciate it. Our next speaker is, Our next speaker is Donna Cornell. Donna is the Vice Chancellor for Legal Affairs and the General Counsel of the University of Houston system, and has been operating in that capacity going on almost 15 years. Donna's range of duties, like any general counsels at a university system, range from intellectual property, trademark, real estate, contracts, litigation, etc. A very broad range. Open government issues, be it public information requests, or be it open meetings laws and how to apply them to each given situation. Prior to joining the University of Houston system, Donna was with the Attorney General's office, ultimately rising to the Deputy Chief of the General Litigation Division, and she also was in private practice for a short while with an Austin-based law firm. Donna's law degree and undergraduate degrees are both from the University of Texas at Austin. Please join me in welcoming my friend Donna Cornell.